All rise. We will obey. Please be seated. We will start.
Yes, as I say, the next item is that of disclosure. Mr. Nichols, you said in your submissions that there were still ongoing investigations. Sorry, I'm just going to find it.
Powers 22 to 23, Your Honor.
Yes. And you're effectively still collecting evidence, and indeed want to re-interview. As I understand the matter, you have access to the Philippines.
Could we maybe go into private session?
Yes. A private session, please.
We are back in open session, Madam President.
Yes, the second matter that has been raised by you is the question of adding new incidents, which the pre-trial chamber left open, and not surprisingly, the defence aren't very happy about that. I think we're going to have to give you a deadline in which, if you want to add new incidents, you're going to have to comply with that deadline, and it's likely to be when we give you the deadline for disclosure.
Your Honor, our date we were going to propose was going to be the end of August, and I can say that we are being conservative in any new incidents we're adding. So it will not be a huge, unmanageable number.
Yeah, that sounds as though you are going to be applying to add new incidents.
Yes, I imagine we will, but I think it will be a few. Some of them are related to existing witnesses where we got more evidence. Some is material that's come in soon, but that fits perfectly within the theory and is just really part of the same case. So, but it will not be a huge number.
Right. Yes, all right. Then, Mr. Haynes, anything you want to say? I mean, as I say, we understand your dissatisfaction.
Your Honour, this was going to be the only item on which I made any substantive submissions today. But in the light of Mr. Nichols' comments, perhaps I'll wait to see what is proposed. I'll give you it in outline. We regard the pleading of what are in effect charges as something else, instances or whatever, as a device to get round the fact that what is in fact being done here is extra charges are being added after committal, which of course would require a return to the pre-trial chamber under Article 61(9). This is a very unusually pleaded DCC. I think if you look back at Abdel Rahman, you'll see that what in that case would have been a topical heading by geographical location or similar, here has been pleaded as a count which in old money I think you and I would have regarded as duplicitous because it alleges 19 murders as a single charge, and of course thereby deprives the trial chamber of delivering different verdicts on each of the underlying acts. But as I've said, I'll keep my powder dry for today. We're not going to be silly. Our real concern is what the parameters of this trial are. If we are to investigate, say, even 50 plus episodes, then that's manageable. But if the suggestion is that we are, in effect, in a sort of public inquiry here, which spans 300,000 square kilometres and a nation of 120 million people over 7.5 years, then this trial really is going to get out of hand and our investigations will be impossible.
Yeah, well, Mr. Haynes, that's fine. I mean, until such time as we see what the prosecution is proposing. I mean, your problem is that the pre-trial chamber specifically left it open. I suppose it's if you go back to the old days, it's like pleading a fraud with all sorts of different instances which are examples of the fraud.
Yes.
But anyhow, I'm sure that Mr. Nichols has heard what you're saying, and Mr. Nichols is fully aware that the trial chamber has every intention of this trial proceeding expeditiously.
Thank you.
Yeah, I'll speak to my friend when we have a chance, and I think I'll be able to put his mind at rest.
Yeah. Yes. Thank you very much. Again, Mr. Masida, I don't think there's anything that affects you on that. Yes, or the registry. So, on the question of outstanding disclosure, I think both of you are agreed, and can we emphasise that the trial chamber thinks is very sensible. Disclosure will go on a rolling basis as before, and the same deadline effectively is going to apply to all of this, these matters of disclosure and the like. Yes, and if there's to be any request for delayed disclosure, could you send that, could you file a motion to that effect as soon as possible, please, Mr. Nichols? And you've got to show good cause, as you might expect.
Yes, Your Honor.
Right. All right. Well, having said the disclosure was likely to take more time, and Mr. Haynes having kept his powder dry, we can move on to transcription. Any updates on what you said at paragraph 28, Mr. Nichols? Or was it more or less the same?
It's no update, Your Honor.
Right. Yes, and we'll, as I say, produce the same deadline. Right, witness protection. As I understand it, from paragraph 31, Mr. Nichols, you will work towards disclosing the identity of all witnesses by the end of September 2026. Does that mean also any new witnesses that you're intending to propose?
Yes, Your Honor.
Right. I mean, if you want to give any updates, it ought to be, I suppose, in private session.
Yeah, no, I don't think any updates. It's just, as you said just a moment ago, if we need to apply for delayed disclosure of an identity, we'll do that
Right.
as soon as possible.
All right. And if there are going to be any discussions about that or anything which needs to be ex parte, then we'll deal with that at the next status conference, or anything that needs to go into private session. And yes, protective measures, obviously, as soon as possible. Actually, I think, nonetheless, we'll just briefly go into private session for a moment.
We are back in open session, Madam President.
Thank you very much. A disclosure by the defence of any defences in accordance with Rules 79 and 80, and at the moment I understand there are none. Is that right?
Yes, I've never known how you could have an alibi to a JCE.
No. Well, yes. In the conduct of proceedings, we'll deal with disclosure in respect of cross-examination of witnesses, disclosure which must be made in advance, but I don't think we need to do that. Right. Okay. Trial briefs, I think, was the next. Mr. Nichols, the OTP says it would 2 months before, I think, the start of trial. You say the 30th of September, if it happened to be the 30th of November. Yeah. And yes, the defence. Ms. Haynes, you have the option, although there's something I'm going to add in a moment, but you have the option of a pre-trial brief, as it were, at after the prosecution or before you begin your case, and I rather assume that you want to do it before you begin your case.
Well, whenever I deliver it, it'll say these are not crimes against humanity. You can have it now if you want.
Well, thank you very much. But there is, however, there's an added extra thing that I want to say about ruling that I want to give about this, which won't surprise Mr. Nichols, nor I imagine you, Mr. Haynes, given your jurisdiction. Article 64.3 of the Rome Statute says that the trial chamber shall confer with the parties and adopt such procedures as are necessary to facilitate the fair and expeditious emphasised conduct of the case. Regulation 54, which deals with status conferences, the first status conference, says that the trial chamber may, in accordance with the statute and the rules, issue any order in the interests of justice for the purposes of the proceedings on, inter alia, the following issues. And two of the issues that are germane to this point are H, the issues that the parties propose to raise during the course of the trial, and P, the defences, if any, to be advanced by the accused. The trial chamber is of the opinion that it would assist the fair and expeditious conduct of this trial, which I referred to in my opening remarks this morning, for the defence to provide a document before the start of trial which sets out, first, the matters which the prosecution are proposing to lead in evidence with which the defence takes issue. Second, sets out in general terms the nature of your defence, and that means going further than saying these are not crimes against humanity, Mr. Haynes. We do not expect you to provide the complete detail of the defence at that stage. The provision of this document does not preclude you from raising further issues at a later stage if those become evident to you in the course of investigations, nor does it encroach upon your right to file a pre-trial brief. And we therefore propose to order you to provide this document 1 month before the start of trial. So is there anything you want to say about that?
No, we'll comply with that, of course.
Thank you very much. Yes. And then I think, unless there's anything... Oh, I'm sorry, Ms. Masidi, yes, as far as the victims are concerned, you may file a brief. I assume it will be before you, if you decide to call any evidence as to the views and concerns of the victims.
Yes, Madam President, our position at the moment, we are still finalizing our internal discussions, but our position will be to file the pre-trial brief before the start of the trial. As it was
yes.
in the Abdullah Rahman case, again, if my recollection is okay this morning, I believe the prosecution filed 1 month after the LRV filed and then the defense filed in the Abdullah Rahman case. We are, of course, open at any order of the chamber. We will comply, no problem at all. Thank you.
That's fine. I honestly can't remember. I rather thought that in the Ar-Rahman case that the defence filed before they started to call their evidence, but I may be wrong.
I think, Your Honour, there was a choice for the opening statements. If there was a choice of doing the opening statements for the LRV as well, at the start of the trial, or once we will request to submit evidence, if ever we will request that. I think this was the option.
Yeah. Well, I'll check. I'll check that over. We're going to have a break before we deliver various oral rulings, and we'll check what that was.
Thank you very much.
Yeah. Pre-trial motions. Yes. The Office of the Prosecutor says 30th of October if the start date is the 30th of November. The defence, effectively going back to the question of the start date, is I'm going to come on to that separately, I think, but a determination of of the accused's fitness to stand trial. Yeah, I mean, do you want to say anything about deadline for the filing of motions?
No, we'll comply with whatever order you make in that regard, Your Honour.
Ms. Masidi, you're the same, are you?
Same as well, Your Honour.
Right, thank you. Okay, well, that brings us on to opening statements, which we've more or less had a discussion of it. We'll come back with the hours at that stage. On the question of victims' participation, yes, I think what we'll say there that the defence invites the deadline for applications by the victims to participate 30th of September 2026, and CLRV request until the end of the CLR case, or at least until the close of the prosecution's evidence. I think we're going to go, as we did in the Al-Rahman case, say that it's going to be the end of the prosecution's evidence, unless there's any objection to that. Mr. Haynes.
Perhaps a slightly different observation, and that is going back to the point that's still in the air, as it were, as to the parameters of the case as a whole. If this case does involve 49 incidents and 73 deceased, then even allowing for multiple dependents, one would expect the number of participating victims to be in the low hundreds and not the high thousands. And Ms. Gibson and I have had recent experience of the harm that can be done in admitting thousands of victims to participate in proceedings, only for them to find out in the reparations phase that none of them fall within the ambit of the convictions, if any. So I would hope there'd be some careful analysis on the part of those assessing these applications as to whether they fall within the ambit of this indictment as it is currently pleaded, because it's doing victims no favours to allow thousands and thousands of them to believe that they might receive compensation at the end of the day, when that is unlikely even at this stage. The other observation I would make, which comes from my experience in the Bemba case, is that multiple applications throughout the trial process overwhelm the defence, because we have to look at them and nobody else does. And we have to review them at a time when we're cross-examining other witnesses or presenting our own case. And so I would invite you to consider whether or not that, given the potentially relatively low number of victims who do qualify to participate in this case, whether that shouldn't be done before the trial starts.
Right. Well, Ms. Masidi, yes, first of all, and then I think I'll go to the registry.
Thank you, Madam President. Just very briefly, I wanted to recall that at the request of a pretrial chamber, the prosecution indicated that the number of incidents are only indicative of victimizations, and they are not to be considered an exhaustive list of potential victims. This was confirmed by the decision confirming the charges, and therefore I suspect, and these are our assumptions at the moment, that a high number of victims will manifest themselves for trial. And our assessment is done by, of course, having contact with the affected communities. And we can already indicate that a number of victims already enter in contact with us to manifest their willingness to participate in this trial. Second, Your Honor, if the prosecution is going to add new incidents, then at that point in time, victims will need time, in any case, to continue to manifest themselves for trial. So the end of a prosecution case seems to us, as in previous cases, the most reasonable deadline in order to effectively grant the right of victims to participate in this trial. Thank you.
Right. Does the registry have any observations to make on this?
Mr. Dubiston, we are completely in agreement with this position, which is also yours. I could also ask Mr. Ambach to give you extra information if you so require.
Mr. Ambach, yeah.
The only point I would have to add to what the legal representative has already submitted, which is also part of what we submitted in our own filing as to the scope of the case, is that the burden on the defense and the prosecutor in terms of the analysis of applications would be minimal if one were to follow the ABC approach that we have proposed to continue from pretrial into trial, whereby only the unclear forms would come to the analysis of the parties and the final decision by the chamber, which, as we also submit, would be minimized to the later stages of trial, which was obviously also a part motivating our suggestion that one were to continue the possibility of victims to come forward until the end of the evidence hearing. Thank you.
Right. Well, we certainly approve the ABC approach. I mean, I think that's now standard through all trial chambers. So, really, the submission of the registry and the victims representative, rather, is it should be the end of trial. Defence say cut-off date, and prosecution didn't say anything really, I suppose, all this. All right, it's one of the ones we'll give a ruling on when we've dealt with all other matters. Witness preparation. a lot of this will be dealt with, as I say, in the conduct of proceedings document, which we'll issue as soon as practicable. Yes, the prosecution can have the same witness preparation protocol as it had in Abdul Rahman. There is and the adoption of the protocol is used for preparation, familiarization and vulnerability will apply as well. However, there's one matter I want to mention because of what happened in the Al Rahman trial. The proceedings were delayed one morning because the witness who was due to appear that morning had requested during the 24-hour, if I can put it, quarantine period before they give evidence to speak to the office of the prosecutor because he had remembered something or wanted to change something. And that request was not transmitted until the morning that the witness was due to testify, when he did give new information, and as a result there was a delay. Accordingly, if that is what a witness requests, and it matters not whether it's a defense witness or a prosecution witness or somebody called by the CLRV, then notwithstanding the 24-hour quarantine period, that request should be immediately transmitted to the party calling the witness, and unless there is good reason why they should not speak to the witness, they should be allowed to speak to the witness and obviously make a note and provide it to the non-calling party. But it was a lengthy delay which was unnecessary and in my view need not be repeated. Right. Unless there's anything else on any of that, it's standard. Right, the sitting schedule for trial. Now this does bring me on to the fitness of the accused, Mr. Haynes. As you rightly pointed out, and you filed a motion to that effect, the finding of fitness related to the confirmation proceedings, and the Chamber is obliged to make a separate finding on that issue. And you very sensibly propose that the three gentlemen who examined him for the purposes of the confirmation proceedings should be re-instructed to re-examine him. And we propose to make that order, hopefully either today or tomorrow. You also ask that they be made available for questioning. I think we will, the first thing to say, it makes sense because these three experts examined him for the purposes of the confirmation proceedings. Therefore, they don't have to go back over all the background that was taken on the last occasion. As regards having them brought for any questioning by the parties, I rather think we'll wait and see what the reports say before we make such a decision.
I agree, Your Honour.
Thank you very much. In that case, as I say, we'll. I only hope that they can carry out the assessment with some speed. So therefore, at the moment, it's a bit difficult to set a schedule for trial until we've had an up-to-date report. But it seems to be that because of his age and potentially medical problems, there will have to be a day off, and I see the suggestion is that it's in the middle of the week. But as I say, I'm reluctant at this stage, without further reports and without an assessment made by the experts of how to set a schedule. So I propose to adjourn that until we find out what the situation is, unless anybody thinks differently. No, I'm taking silence as assent. The representatives of the victims finally want a secure and private remote room. I think you have to take that up with the registry. I mean, if they can arrange that, that's fine by the trial chamber. It's not really a matter for us. The final matter was the suggestion by the prosecution of an alternate judge. I don't think that really is necessary. All right. Are there any other matters? We're going to adjourn, and I suppose we could try and do it before, just to go through the rulings we're going to make. Just give me a moment. I'm reminded, Mr. Nichols, I should have asked you, have you got anything to say about the experts examining him?
Well, you've made your decision, so no. We would have, but you've made your decision.
It didn't occur to me that you were going to object, but...
We had something... No, we accept that. The one point I would make very briefly is we would hope that your honors would instruct the experts. We would not agree with the defense's proposed letter of instruction
in
its entirety.
Yeah, I forgot about that.
Some of the points we feel we would take issue with, but so we think your honors should do the instruction according to the test from Strugar and Hadzic and Bagbo. And so appreciate the trying to save time and be helpful, but we would not agree with this letter going as is.
Yes, all right. All right. And in fact, quite rightly, of course, the people are going to be concerned with the registry. Is there anything you want to say on that, Mr. Dubuisson?
No,
Mr. Dubuisson. No, I believe that to find experts that are immediately available and who know the interested party, I think that this is the best solution. And today, I do not believe that they will deviate very much from the previous recommendations.
Well, yes, we'll have to see what they say rather than anticipating it. Okay. Yes, Mr. Haynes, all right, so the prosecution doesn't much like your letter, so I think the chambers will write...
we were only trying to be helpful.
Yes, thank you. All right, yes, I'm sorry, I forgot about that. All right, what we're going to do is adjourn until 2 o'clock, just so that we can take time to consider the various matters being raised. Before I do that, however, can I just say one last thing, which really has no bearing or impact on the case or how it will be conducted, but for the purposes of transparency, knowing that there is public interest in this case, I should say, and this is myself speaking rather than on behalf of my fellow judges, it's probably well known that the world and the pool of international criminal law lawyers and judges is a limited one. And it is therefore probable that judges and counsel will have met before this case or during other cases, or possibly at conferences or even social events. In this case, as it so happens, I know counsel on both sides. As far as Mr. Nichols is concerned, apart from the fact that both he and Mr. Jeremy appeared as prosecution counsel in the case of Al-Rahman, Mr. Nichols and I worked together now over 20 years ago as counsel at ICTY. Mr. Haynes and Ms. Gibson, Mr. Haynes I've known, though not in a professional way in the same way as Ms. Nichols, for almost as long, and Ms. Gibson for less time. We have met and, as I say, are likely, almost certainly, to meet again at seminars and social functions. Although it's not possible to predict that with any certainty, the one thing it is possible to say with certainty, there will be no discussion whatsoever of this case between parties and the judges at any such functions. And as I said already, it has no impact on the way that this case will be conducted or any rulings that may be made by this chamber in respect of submissions made by all sides. So thank you very much, and we'll adjourn until 2 o'clock.
All rise. We will.